Authorizes the Director of Public Property to purchase a portion of real property on Eagle View Boulevard for the use and benefit of Metro Nashville schools. This had been deferred by Planning and Zoning, and I think there is a substitute or an amendment, Mr. Jamison? No? Okay, we're just bringing it back. Okay, do we have a motion? Been moved and seconded. Any discussion? All those in favor? Any opposed? Up to 12. Okay. Next is Resolution RS 2016-362, sponsors O'Connell, Allen, and Elrod. This authorizes Pappas Properties LLC to construct and install an aerial encroachment at 600 11th Avenue North. Do I have a motion? Been moved and seconded. Is there any discussion? Seeing none, all those in favor? Any opposed? Bill is recommended. Next is RS 2016-363, sponsors O'Connell, Allen, and Elrod. This also authorizes Angry Husk Holdings LLC to construct and install an aerial encroachment at 115 2nd Avenue North. Do I have a motion? Been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Resolution is recommended. Withers is here. We're up to 13. Next is RS 2016-364, sponsors O'Connell, Allen, and Elrod. This authorizes Good Times LLC to construct and install an aerial encroachment at 421 Broadway. It's been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Resolution is recommended. Next is RS 2016-365, sponsors O'Connell, Allen, and Elrod. This authorizes Sky House Nashville LLC to construct and install an aerial encroachment at 111 17th Avenue South. Been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Resolution is recommended. Next is RS 2016-368, sponsors Sledge, Anthony Davis, and others. This recognizes the expanded duties of the Metro Housing Trust Fund Commission and the roles of the Mayor's Office of Economic Opportunity Empowerment and the Metro Council in ensuring a comprehensive approach to affordable housing in Nashville and Davidson County. Been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Resolution is recommended. Now we're to bills on second reading. First is BL 2016-325, sponsors Dowell, Allen, and Bedney. This amends 63 acres of the Ridgeview Urban Design Overlay District for property located at Bell Road, unnumbered, approximately 500 feet east of Bell Road, to permit a mixed-use development with applicable design standards. This hasn't a proposed amendment. Okay, so we need to move the amendment. I think I heard it moved and seconded. Any discussion? Okay, all those in favor of the amendment? Any opposed? Amendment is recommended. We need to move the bill as amended. Okay, it's been moved and seconded. All those in favor of the bill as amended? Great. Bill is recommended as amended. Now we're on 2016-380. Sponsor is Glover, authorizes the acquisition of property located at 7 Point Circle, unnumbered, for the isolation of a sewer odor control station. Been moved and seconded. Any discussion? Seeing none, all those in favor? Any opposed? Bill is recommended. Hagar is here. We're up to 14. Okay. Now we're on to bills on third reading. Substitute Bill 2016-133, sponsors Allen, Bedney, and others. This amends the Metro Zoning Code to incentivize inclusionary housing with any residential development that seeks additional development entitlements beyond that permitted by the current base zoning district. There is a proposed substitute, so we need to start with the substitute. May I get Mr. Jamison to explain the substitute, please? Take your time.
The second substitute originates from several sources, including the Planning Commission meeting of July 21st, which added a provision in several sections, making specifically in subsection B of 1740-780, the application occurs when additional residential developments are gained through an amendment rather than sought. It also addressed the funding cap limits when that financial incentive became unavailable and could be adjusted when that occurred. The additional amendment addressed or substitute revises the original substitute to state that in lieu of construction may also be extended to those developments that are as far as a half mile for inclusionary housing, not on a multimodal corridor. It revised subsection C thereof to address incentives for rental units, specifying that it is for rental units, and revises the percentages of those incentive funds within the UZO from 20% to 12.5% of the total floor area, and outside the UZO from 20% to 10% of the total residential floor area. It references or corrects a reference to the Metropolitan Housing Trust Fund Commission to the Office of Economic Opportunity Empowerment with assistance from the Finance Department in applying those incentive percentages. It makes a housekeeping correction in reference to the Metropolitan Housing Trust Fund Commission, again to the OE with assistance from the Finance Department in section 1740.800. And finally, provides a sunset provision of December 31st, 2019, rather than the 3-year reference. Lastly, there was a reference that this would be enacted after 9 months, and this would remove that enactment period and make it effective October 1st.
Thank you. Okay, I have some members in the queue. Councilmember Glover.
Thank you, Chair. So with this, let me just make sure I understand. We now put it back in there that if you wanted to do like an SP as an example, you now have to do 10%. This is for sale units, correct? You have
For
to put
sale
10%.
units are totally voluntary. We do still have set-aside recommendations in there, but there is no obligation to do for sale unit, to do set-asides for sale units.
Okay, so there will be no penalty if they decide they do not want to do it.
That is my understanding, Mr. James.
Mr. Jamison, is that correct?
That is correct.
Okay, all right, because I'm not seeing that, but I'll take you at your word on it. Okay, thank you.
Other questions? Okay. Mr. Goldman.
Thank you, Madam Chair. Mr. Jameson, would that necessarily constitute Article 4, in your opinion, as being legal?
It would. I would recognize that there is certainly a strong difference of opinion, and I know the council has been contacted by at least 1 to 2 outside agencies. I might take this opportunity to simply review the brief history of this bill and how careful attention was paid to the state of state legislation as of last year. The letter that the council received on July 28th from the Beacon Center stated that this bill, 133, requires landowners to give up a constitutional right. With all due respect to the Beacon Center, because I do appreciate their insight, I think they are misreading it to state that it is a requirement and misstating it to state that it is a constitutional right. There is no constitutional right to a rezone, particularly an upzone. The statute in question, it's 6635-102, and the operative language says this: a local government unit shall not enact, maintain, or enforce any zoning regulation, requirement, or condition of development imposed by land use or zoning ordinances, resolutions, or regulations, or subdivision plan that requires the direct or indirect allocation of a percentage. It has been the rubric, the regime imposed and envisioned by 133 that this be optional, not mandatory. It only kicks in, as the second substitute would state, once you have obtained an entitlement, an enhanced entitlement. So it is not imposed on anyone without that step. This council was aware of that statute last year. In June of last year, the council passed a resolution urging an amendment to the state legislation. And then 6 weeks later, the council passed the ordinance that led to this road, sending to the planning department the task of preparing what became 133 with the specific objective of complying with all state regulations, including what was specifically cited in the ordinance 6635-102. Planning was aware of that restriction and that request. In their consultant's report, the 130-something page consultant's report that we got, he addresses specifically the state legislation, notes that the legal department has prepared an opinion stating that we believe, as they put it, the executive director of the Metropolitan Planning Department, subject to the requirements of Section 171002 and all, shall include without limitation TCA 6635-102 in its compliance. The consultant's report notes that Metro Legal Department has issued an opinion regarding this matter, and it does not appear that a court would invalidate a law under which a developer is not required to provide affordable units. And again, that is, as I understand it, the lifelong intent of this legislation, that it not be mandatory, but rather optional. And in fact, you'll note that the line in 133 states that this is a required, or this is an option for the developer only so long as financial incentives from the Metro government are available. There is also the financial incentives grant component of this in 342 that accompanies it. Lastly, I would just note that stemming back 80 years, the General Assembly has imbued local legislative bodies with broad zoning powers. There are some interpretations under Dillon's rule that we are only entitled to enact legislation in those areas in which we're specifically allowed by the General Assembly to do so. We've been allowed broad zoning powers for the past 80 years, and it is the specific intent of that legislation, as the state itself says, for the purpose of promoting the public health, safety, morals, convenience, order, prosperity, and general welfare, which I would submit what 133 is an effort to do. This is a zoning bill. It is an amendment to Title 17. There is no constitutional right to a rezone. Lastly, I would simply note that the substitute makes some pretty significant revisions to the bill subsequent to the correspondence you received from the Beacon Center in July. So I know I've talked too long, but that is the basis of at least the council office's opinion that this does meet constitutional scrutiny.
Okay, and just finally, when you talk about the standards of requirement, are you saying that as long as you stay within the standards, then you don't have to worry about an enforcement of voluntary or involuntary? But once you want to zone for more than the standard, then this bit about requirements take on a new effect.
Right. That's the underlying philosophical difference, is that the statute that the state legislature passed prohibits us from requiring it. 133 does not require that you provide affordable or workforce housing. Only in those instances where you not only seek but gain additional entitlements do the provisions kick in.
Okay, thank you.
Good question. Other questions? So we are voting on the second substitute, and then there are amendments that we will...
Optional.
Optional. Okay, but we vote on the substitute
Right.
to move from the first substitute that we vote. Okay, so if there's no more discussion on the second substitute, all those in favor say aye. Aye. Any opposed? Oh, I'm sorry.
No.
Yes. Okay. Councilmember Colby Sledge is personally requesting a roll call vote on the second substitute. So all those in favor of the second substitute, raise your hand high. Thank you very much.
All right, keep them up.
Keep them up. Okay.
Connell. Archer and Glover.
And me. Okay, thank you. You can rest your hands. All those opposed? One moment. All right, so I got
And 0 against. All right.
Thank you. Okay, that's 12 in favor. There are several amendments that were in the packet. I would like to move an easy one, which was the one that simply added the same language that's in BL 342, which we will consider later, which says this bill sunsets in December 31 of 2019 unless renewed by resolution. And that's the same language that's in 342, which makes those consistent. So that's it's the third amendment, or the last amendment in your packet.
Right.
Is there a second to that amendment?
Second.
Okay, any discussion on that specific amendment? Okay. All those in favor? Any opposed? Okay. Okay, and I will bring this up for the purpose of discussion. There is also an amendment to reinstate the 9-month waiting period. This was put back in the packet because we have worked very hard to get the support of the development community, and there were a number of communications indicating that pulling that 9-month waiting period out would result in the loss of their support. So I would like to reopen the discussion on the 9-month waiting period. I see 2 people in the queue. Councilmember Glover.
I just want to reaffirm on this that I was trying to scan it very quickly to find that it's voluntary on the for sale unit.
That is correct. If
okay.
you, there are several different places under applicability.
Okay.
Where that it says this applies to for sale. I mean, this applies to the rental only, for sale is optional. It's in the applicability standard. And then we've added some language in several other references where it gives percentages for sale, but it specifically sticks the word rental in to make it clear that it's only obligatory for those.
So let me just get clarification, because it is voluntary now only on the for sale. This is not the rental units, on the for sale units. And it's recommended 10% if you're above the 80% or AMI or whatever it was. If that's the case, if money is available, then if a builder so chooses to exercise this, then there would be supplemental money that could be provided to them if they want to participate. If they don't want to participate, then there's no financial penalties whatsoever.
That is my understanding.
Correct.
And Mr. Jameson is.
Correct.
Okay. All right. Thank you, Chair.
Thank you. Mr. Sledge.
Thank you, Madam Chair. Could you articulate or maybe go into a little more detail about what the, I guess what we're calling the business community has said regarding this amendment?
Yes, I will say what I have heard, which was they felt that had been offered early on. They did not realize, although I think we did bring it up several ad hoc committee meetings earlier, that we had felt like that might not be necessary because of other concessions we had made. They had said they had not been aware of that. Secondly, what I appreciated hearing was that seemed to be the only sticking point at this point, that they were supportive of the other changes that we had made, and that they would not oppose other changes. And since we have bent over backwards, in my mind, to accommodate them, I'm appreciative of them making the statement that they are supporting all the other many things that we have done to make this work for them. And so I agreed to bring this amendment back up.
So my next question is a procedural question. In our packets, we have a 9-month effective date and a 6-month effective date. Is the 6-month effective date, are we planning on taking that one up depending on our actions of the 9-month?
If a sponsor chose to move the 6-month, we could take that one up.
Gotcha. Okay. And then the last one is just a comment. I know we've talked about the 9-month period, and we had pretty good discussion in the ad hoc committee about this. I think it's important to note that, as district council members, we will still have, I think, probably varying degrees of affordability, of how we want to see affordability enacted in our districts. And so one of the reasons that I had proposed putting a blanket date, an enactment date that's in that current substitute that we just passed, was so that there'd be a level playing field. I fear that this amendment may create an unlevel playing field, but if the business community feels like that's something that they can live with, then I can live with it too. So thank you.
Councilmember Withers.
Thank you, Madam Chair. Similar to Colby, have been contacted by a number of architects and builders and folks in District 6 and who have been participatory and have supported a lot of the affordable housing discussion that's gone on for so long, and that was their one request, is to leave in the 9 months effective date. And other than that, they're very, very supportive of that. So I would like to speak in favor of the 9-month amendment as well.
Oh, okay, thank you. Councilmember Coleman, do you wish to speak again?
Yeah, I think the last time I spoke, it was on the other amendment,
Okay.
so it's not the first one. Okay, going back to your description of the business community, I take it that you're talking about the 9-month waiting period. Is that?
That is,
Okay.
excuse me, specifically what we are addressing at the moment.
Okay, because if you're saying that they're happy with everything else besides the 9-month waiting period, then I guess I would take you up on what I've heard, and that is they thought that Article 4 was unconstitutional. However, Mr. Jameson have explained it, and he has opined, so we accept that. But I just want to include that I got calls the opposite way as it relates to the affordable housing. But, I mean, that question is settled, but when you say that was the only point, the 9-month waiting period, I just want to clear, there were some other issues that concern the business community. But if you're talking about only the 9-month waiting period, then I will accept that. But make no mistake about it, they do feel that Article 4 is something that's going to be challenged. I don't, but that's the business community.
And clearly, you know, there is no monolithic statement, so, I mean,
Okay. All right, thank
people
you.
have different opinions.
Thank you.
Thank you, good statement. And next, Councilmember Bedney.
Thank you, Chair. Well, first of all, as I wanted to thank everybody, both in this room and outside this room, that have participated over the years in trying to find a compromise on how to deal with this terrible problem we're facing in Nashville, which is that people are being pushed out of the city that they helped build for generations. And this is just an effort to try to reduce that displacement of people from the city and to provide some stability so they can stay here and grow their families. I am supporting this 9-month request reluctantly, but I am supporting it because I too have discussed this with people in the business community, and they have shared with me that they need to be able to plan for the long term, and some of them have already invested money in one type of model of creating developments, and this will change horses at halfway. So I'm in support of this. However, I do want to say that we have been very open and receptive and invited everybody, every stakeholder to come to the HUC meetings and share with us. And I know, Council Lady, you have been amazing in working with people, and many of the people in here have done that as well. Regarding the Beacon Center, well, this is a organization that believes that we shouldn't have zoning and things like that. So you got to take it within the context of where they are coming from. Obviously, they don't like. If it was up to them, we wouldn't have to be here. They'll just leave it to the market to make decisions about everything. But we are asked by the people of Nashville to create a better city for all, and that's what we are doing. So I'm encouraging you to support this amendment, and thank you very much.
Thank you. Seeing no one else in the queue, all those in favor of the amendment to reinstate the 9-month waiting period, say aye. Any opposed? Thank you. That was 15. Next is,
As amended.
okay, now we vote on the substituted bill as amended. Any other discussion? It's been moved and seconded. Seeing no new names in the queue, all those in favor? Aye. Any opposed? Yes. Excellent. Next is BL 2016-268. Sponsor is Scott Davis. I do not see the sponsor in the room, but I do have a letter to defer indefinitely. Do we vote on that?
No.
Okay, so we will defer that indefinitely. Next is BL 2016-298. Sponsor is Scott Davis. There is a proposed substitute, and I have a letter to approve. Can I get someone from planning to talk about the proposed substitute? You should be on.
The proposed substitute has been reviewed by the Planning Commission and recommended for approval.
It's been moved and seconded. All those in favor? Aye. Any opposed? Okay, now we will vote on the bill as substituted. Okay, we are voting on the bill as substituted. All those in favor? Aye. Any opposed? Bill is recommended as substituted. Finally is BL 2016-304. Sponsor is Ed Kendall. This changes 0.29 acres from R6 to SP zoning for property located at 1036 33rd Avenue North to permit 4 residential units within the existing structure. And I do have a sponsor from a letter from the sponsor to approve. Thank you. Okay, it's been moved and seconded. Councilmember Johnson, would you like to speak?
Thank you, Madam Chair. I think we did discuss at the last Planning Zoning Committee meeting very unusual nature of this SP zone. So if you would, planning, explain to us one more time, and then I would like to make comment.
This particular ordinance is to allow 4 units within the existing structure only. If the property redevelops, it would have to go down to 2 units. The Planning Commission did recommend approval.
Councilmember Johnson.
Thank you. I think one of the condition is if this structure is going to be rebuilt, it has to follow duplex zoning, R6 zoning, so that will bring to conforming use rather than legally non-conforming use. Is that correct?
The 4 units right now are not legally non-conforming. They are not permitted. This would allow them to have 4 units in the existing structure. If they did redevelop, it would be similar to the zoning around it, which is R6.
So I think my main concern is, I think it's clearly, I'm hoping it's clearly stated in the bill about when this structure is rebuilt, we don't want to allow another illegally non-conforming quadruplex. So I just want to make sure it will not happen.
My understanding is that is stated in the bill. Can you?
That is stated in the bill. However, the quadruplex was created without permits, and so nothing would prohibit a future owner from converting it without permits, though they would be cited through the codes department and the zoning would be enforced as a 2-family structure only.
Councilmember Murphy.
So I think Mina covered what I was going to ask, and I spoke to the sponsor about this because I've spoken to Bill Herbert and Mike Jameson about this because I had concerns about why this wasn't going through the Board of Zoning Appeals to seek like a land variance or something, because it seems like we're basically making a legal variance for them. Is that a fair characterization of this zoning?
This would actually change the permitted uses. I don't believe that you can get a use variance, but I'll defer to the Department of Law on that.
Oh,
You can't. She's correct.
okay.
Okay, I think it makes sense. And so would they be able to, and you may have just answered this with Mina, but I had a different legislative issue going on. So could they use this to legally non-conform and build something else? Like, because it only goes back to R6A if it's torn down, but can they use the same footprint and do a non-conforming use and expand with this?
If this will be a permitted use once it's rezoned, so it would no longer be a legally non-conforming use. They are limited to the existing structure, and if redeveloped, they would have to comply with the zoning, which would only allow 2 units.
Redeveloped in any way?
I mean, they have to comply with the zoning by keeping it within the structure. I don't think they could expand under this. If they wanted to then demolish, they would be limited to 2 units.
Okay, thank you.
Any further questions? Okay, we have a letter to approve. Any other discussion? Seeing none, all those in favor? Any opposed? Bill is recommended.
Can we go back?
We have been asked to go back to,
268 and vote on the deferral.
oh, we do need to vote on the deferral, excuse me. 268 was, we had a letter to defer indefinitely. We do need to vote on that. Thank you. All those in favor of deferral of 268? Any opposed? Bill is deferred. Okay, is there any other late business? Yes, sir, Mr. Bidney. Let me back up.
Did we vote on 371?
What reading is it on?
It's on the list. Okay, never mind.
Okay. If it's not referred to us now, we'll get it the
I'm
next
jumping
time.
the gun.
That's
Thank you,
okay.
Chair. I welcome you all to come to a ad hoc meeting. in
Ad
the
hoc meeting.
next
Thank
one.
you very much.
Thank you.
We are adjourned.